given direction, some of which has been ignored. So I think as a nation, we also just need to develop the culture of constitutionalism and respect for the rule of law. Because when the court, with its authority, has made a pronouncement on an issue, then it's only right that we comply and we follow what has come from there, unless there is subsequent legislation that changes the position. And having that understanding in running a big and busy institution, it's very clear to me where the role of the chair ends and where that of the secretary begins. So that is an advantage I'll be able to bring on board, so that we don't have an issue of overreach on the side of from the commission to the secretariat. It's also important for the chair to be able to, in a sense, protect the secretariat or the secretary and CEO from interference by members, because that does happen. And so if the secretary is exposed and doesn't have the protection of the chair, it then begins to compromise services, and it begins to affect work. It's also the responsibility of the chair to make sure that there is compliance with all the principles of governance. We have the Mwongozo governance framework that guides all public institutions, and having worked with that document, it gives an advantage to be able to manage the commission well. A chair has to have high emotional intelligence, which is a skill that I have, so that you know what to do at the right time. You know how to deal with emotions of other people. You understand when to push something, when to step back, and you also know how not to overspeak under pressure, not to operate in panic. So those are skills that I would want to bring to the commission.
Maybe you could also expound or give information to this panel on whether or not you have any special skills in terms of information, communication and technology, because the future of Iebc truly is electronic.
Yes.
Do you have any such skills?
Yes, indeed. I actually oversaw a very robust digital transformation in the Kenyan judiciary. We moved from analog to a digital institution. And one thing that gratifies me the most is that all of it was done using internal capacity. We did not have, we had previously procured different systems that never worked. But when we began to now enhance the capacity of our ICT directorate and to just compare what other jurisdictions had, we allowed the team to run with it, because all they were able to do was come and do a presentation on what they were capable of doing. And as the chief administrator of the judiciary, it was my responsibility to facilitate them to be able to do that. So we ended up, initially it was under a lot of pressure during COVID. We were able to come up with virtual courts. We were able to come up with e-filing and other platforms without spending any extra money. And that is good for sustainability, because then the judiciary currently doesn't pay for any licensing, which is very expensive, because some of the initial ICT initiatives that failed was as a result of budgetary constraints, so that you have the money for this year, then the subsequent year there's no money for the license, then you're cut off. So that is a thing of the past, and that has continued to develop and to grow, and I don't see why the same cannot happen in the Iebc, considering that ICT is one of the main cost drivers in the running of an election. Yes, thank you.
Yeah, thank you very much. Thank you, Chair.
Just a bit more follow-up. As a CRJ, You talked about running the judiciary day to day. What are those competencies that you needed to have to do that? Just briefly.
Briefly?
Yeah.
Okay. You needed to have managerial skills. You needed to have communication skills. You have to be able to communicate because there's so many things happening at the same time with very many different stakeholders. There's communication to go to the lawyers. There's communication to go to the court users committees, to the NCJ, to the Witness Protection Agency. So communication was very, very important. And because of the high pressure, the nature of the work, just taking an example of during the elections period when there's so many petitions being filed post-election, you have to have resilience. You have to be able to put in many hours, just hard work. You have to be able to guide. You have to be able to rally people around an issue so that you move together. You have to have very good coordination skills so that you know what every court is doing at any given time. You have to know what they need at any given time. You have to make sure that they're provided. You have to have very good financial management skills. You have to be able to ensure that procurements are done on time. There are no delays. Sometimes we had difficulties when budgets were released late, but then there would always have to be a way of doing things in such a manner that services are not interfered with, are not stopped. Again, we had to have it was important for us to know what the public feels about our services. So it was about reaching out through the court users committees, through our customer surveys, just to be able to know what is it that people want, what are we doing wrong, how can we do it better. So those are some of the skills that we had to put to use.
Fair enough. Thank you very much. I would like to ask Madam Carol Kituku to ask some questions, kindly.
Thank you so much, Chairman. Honorable Amadi, if you are appointed the chairperson of the IEBC, your knowledge of the law and the legal systems that governs the IEBC will be critical in offering the strategic leadership, direction and guidance to the Commission. As you may know, Parliament is required to enact various laws that give operationalization to the various segments of the IEBC mandate. One of those laws could be the referendum law, the financing of campaigns law, the boundaries delimitation laws, just to mention a few. However, those laws have not been enacted to date. What do you perceive that to be, and how does that interfere or present challenges to the operations of the IEBC? The failure to enact those laws.
Indeed, the failure to enact laws to operationalize the IEBC should be a concern to all of us. For example, on the issue of the referendum mentioned, currently we do not have a framework for conducting a referendum, so that if we needed to have one today, then there will be a challenge. How do you do it? How do you even frame the referendum question? I'm aware also that Article 100 that talks about the participation of women, persons with disability, the marginalized and all that, has not been operationalized. So it leaves us in a place where it is difficult to meet the objectives of the Constitution and what was envisioned by Kenyans when they demanded for those things in the making of the Constitution. I'm also aware that the IEBC has attempted to seek advisory opinions on some of these matters. For example, where we have delay in the issue of boundaries delimitation, So what happens? The Supreme Court has also delayed in giving that, meaning that then there is no clarity on how we move in terms of conducting the boundaries delimitation. The Campaign Financing Bill Act was stopped by the court for certain reasons. It was a good law, according to me, that would have helped us to decommercialize campaigns and elections. It would have helped us to be more accountable, more transparent in the sources of funding when it comes to elections. But there is a conservatory order that is still there since 2017, and I think that issue needs to be resolved. And some of these issues can be resolved just by reaching out and having continuous engagements with the different stakeholders. I know that Iebc is not a member of the National Council on the Administration of Justice, which is the council that brings together all justice actors in civil society, the state actors as well. But Iebc was actually co-opted as a member of the National Council. So that would be a good forum, because I know that at some point Parliament also joined in. As secretary, they were not very consistent in attending, but that would be a very good forum to discuss these challenges, because it's in the interest of all of us that the Constitution is implemented as envisioned, and for as long as these areas remain hanging, then it means that there is something that we're losing, there's something that we're missing out on as a nation. Thank you.
Maybe a follow-up question on that. If you're successful and become the chairperson of the Iebc, how do you propose to circumvent some of those challenges that have been brought about by the failure of Parliament to enact those laws, the lacunas in laws? Because in the meantime, Iebc must perform its mandate.
What I see as an immediate low-hanging fruit is just continuous engagement, and also getting the general public to understand those issues. I know that Iebc engages a lot in voter education, and my view has always been it shouldn't just be about how to vote, how to use the ballot, but why should I? Am I picking people who are going to make sure that these things get to happen? So we have to keep engaging at all levels, from the parliamentary level, Senate, and then the general public, other actors, so that we just develop a shared vision for this nation. Things that I think going forward, my view is that in Kenya we legislate a lot. We legislate on almost everything. There are certain things that there should be room for just administrative action, so that we are not waiting for law to be able to do everything. I think there is that issue of trust, and so because of that we tend to legislate even the smallest thing that can be done just administratively through maybe a policy framework, and then that would be my view. Thank you.
Having worked as a judicial officer, and obviously having had the experience of working as a chief registrar of the judiciary, how do you see, or what do you think is the role of the court in adjudicating electoral disputes, and particularly these disputes that regard to the lacunas in law? Does the court have any role or any function to do?
Okay, where there is, I'll begin by saying that yes, the court has a big role in adjudicating electoral disputes, and the legal framework allows for, we have the Political Parties Disputes Tribunal, which is a subordinate court under the judiciary, and then during the electoral, the election petition periods, we have courts gazetted to deal with disputes. So indeed, the judicial officer has a role to adjudicate on electoral disputes. Does the court have a function where there is lacuna in the law? Yes, it does, and mostly at the level of, because legal interpretation, constitutional interpretation, is a function of the High Court. So if a question comes, a question arises, the court would have an obligation to make a pronouncement. There is law that is called judgment law. I think the law can make a pronouncement that can guide. I know that the Supreme Court has dealt with a few advice given direction, some of which has been ignored. So I think as a nation, we also just need to develop the culture of constitutionalism and respect for the rule of law. Because when the court, with its authority, has made a pronouncement on an issue, then it's only right that we comply and we follow what has come from the, unless there is subsequent legislation that changes the position.
The court to pronounce itself on this issue. Can the IBC go to court to can IBC go to court to compel Parliament to enact these laws and provide the required legislative framework? Is that something that would be that within the mandate of the court to do? Politically ideal for IBC to do so?
IBC compelling Parliament to legislate. I think IEBC can go to court and ask for anything. My only doubt is whether it would be the right way, the right path, because I believe more in engaging with the lawmakers, taking into account the view that if the lawmakers are hesitant to legislate on a particular thing, because we know that the courts have also pronounced themselves on certain issues that Parliament has still not done. So we also don't want, even as you consider that as an option, you don't want to go through a process of that nature in futility. So I would still prefer the engagement, negotiation process as opposed to an order which might be in vain. But yes, indeed, the court can pronounce itself and say, indeed, this law has to be passed because the Constitution says so. Yes. Thank you, Chair.
Given that during your time at the judiciary, there were constant complaints about inadequate funding.
Yes, I engaged a lot with the members, especially of the Justice and Legal Affairs Committee and the members of the Budget and Appropriation Committee. And when I joined the judiciary, the budget was about 16 billion. When I left, we were at about 23. It was still way below our resource requirement, but progressively it was increasing annually. So we have to just keep at it, because the option is not to push for it and remain with nothing. So we kept engaging both informally and formally. During the budget discussion processes, we would prepare our resource requirements very well and explain the justifications for all those requirements. And we'd constantly compare the budgetary allocation for Parliament, which only operates in Nairobi, with the judiciary that has about 140 court stations across the nation. When I joined the judiciary in 2014, our budgets were at par, 16 billion, more or less. And within 5 years, Parliament had double the budget of the judiciary. Yet they operate only in Nairobi. They have very few staff compared to the judiciary. So they have that advantage that it's them to decide the appropriation of of resources. The judiciary is, and it's not unique to Kenya, it is something that you see across the jurisdictions, that the judiciary tends to be the poorer cousin of the three arms of government. So it helps, it does help, because there are times when you're able to push and get something more, and you keep using it as long as you're using it with prudence. And as I said earlier, we had very little money, but money to have a very vibrant and robust ICT system, just with the little that we had. So we were able to be prudent in the use of resources, apply little to do much. So if you don't have enough resources, then it's about how do you apply it to maximize on what you have. Thank you, Chair.